I'm Jeffrey Rosen. I am the president and CEO of the National Constitution Center, and I've been here for about a year and a half, since June 2013. So how do we translate the Constitution in light of new technologies? This is, I think, one of the most exciting questions in constitutional law, and the bottom line is there are no clear answers. You can argue it round or you can argue it flat. To say the framers clearly would have forbidden or blessed NSA surveillance is obviously silly, since there was no NSA surveillance at the time of the framing. There was a great exchange between Justice Scalia and Justice Alito about this question in the case. It was actually a case involving violent video games. And Justice Alito said, well, Justice Scalia wants to know what James Madison thought about video games. And Scalia said, no, I want to know what he thought about the First Amendment. They also entertainingly and wittily clashed in the case involving GPS surveillance. Alito said, the framers didn't think about this technology. There was no GPS devices. And Scalia said, no, but there was an analog. At the time of the framing, you could imagine a constable hiding under a carriage and eavesdropping on the conversation. So we have to think about what they would have thought of the eavesdropping constable. And Alito said, well, since it would have taken 1,000 constables to get the amount of information that a single GPS device can get over the space of a month, you'd need very small constables or a very large carriage. Really good line, and it shows how hard it is to come up with framing era analogies for modern technological questions. So all that means is that there are not clear answers to these debates, but it doesn't mean that the history isn't deeply relevant. So let me, as concisely as I can, summarize the best arguments on both sides of the Fourth Amendment and NSA surveillance. I'm drawing on two phenomenal debates we had here at the Constitution Center. We did a IQ squared debate, intelligence squared debate on this question, which you can check out on the IQ squared website and on ours. And we also did a phenomenal podcast on it, which you can check out on our We the People podcast. So if you're going to decide whether NSA surveillance violates the Fourth Amendment, you start off by telling those framing era stories that I told a moment ago. The framers are concerned with general warrants and writs of assistance that allow the king's agents or government agents to collect a lot of information, much of it innocent information, without a particularized warrant, in a search for guilty or incriminating information. It was a fear of, as James Otis said, the petty discretion of an officer and of looking for needles in haystacks. So then we turn to NSA surveillance. Is the collection of metadata, that is the telephone numbers that we call without a warrant for every domestic and international call in and out of the US, a violation of the Fourth Amendment? Now, you can argue it round or flat, as the lower court judges have. One court, led by Judge Richard Leon in D.C., said James Madison would have been aghast at NSA surveillance because it's precisely like the general searches that the framers were trying to prohibit. He said because our metadata can reveal so much about us, the people we associate with, our intimate activities, and our political beliefs and our hopes and fears, a warrant is presumptively required. Other courts, including the Foreign Intelligence Surveillance Courts and a district court in New York, disagreed. They said because metadata doesn't reveal the content of our conversations, but just the people we called, and because the court in the 1970s, in a case called Smith and Maryland, said that when we make local telephone calls, we voluntarily surrender those numbers to the phone company and have abandoned all expectation in privacy in them, therefore no warrant is required. So the framing era history doesn't settle the question, and I can draw further distinctions about whether metadata is or is not like the writs of assistance that reveal the content of the colonists' desk drawers. I have my own views on this as a law professor, but as head of the National Constitution Center, I'm delighted not to bore you with my views and tell you to check out our podcast so you can make up your own minds. But it's just really relevant and important to study that framing era history so that you can engage in this task of constitutional translation. One thing I do think judges have an obligation to do is to accept the challenge of translating these framing era stories into new contexts. It's not enough merely to say, well, the court decided in 1973 that when I used a rotary phone to dial a local call number, I surrendered all privacy expectations. You've got to at least engage the arguments on the other side, namely that there's a huge difference between one rotary phone call and my cell phone and all of the calls and electronic data collected there. It has the potential, at least, to reveal far more about us. And then you can decide for yourself whether you think it is or isn't like a general warrant. But you've got to at least recognize that all of the hard, interesting constitutional questions are open. They're not clearly guided by current law. And that's why the whole enterprise of constitutional translation is so exciting. There's a lively debate in constitutional law about whether the framers intended for future generations to be bound by their own original intent. And some scholars, led by Jefferson Powell, have said that they didn't intend for their own intentions to be binding. They thought that future judges would engage in the process of common law judicial interpretation that was familiar to them from English courts, and they expected that the law would evolve as it always had in the course of ordinary decision-making. Others, distinguished scholars and judges, led by Justice Scalia and Justice Thomas, take a different view and say that original understanding should bind, perhaps not even because the framers specifically intended it, but because democratic theory requires that only the text as understood in its original context is the supreme law of the land, and for judges to substitute an evolving understanding for the understanding ratified by the people themselves is an act of judicial usurpation. I'm not going to tell you which side to take there. There are really good arguments on both sides, and we could talk for a long time about that. As to how much technical knowledge is necessary to decide these cases, some of the justices have got ribbed on the blogosphere for their lack of technical knowledge. Justice Kagan has joked that I think she's the youngest justice, and the technology she remembers from her youth is Pong when it comes to video games. Tragically, that's my generation of video games as well. So, you know, how she said, can we presume to know the most up-to-date stuff? On the other hand, she did not suggest, and I agree with her, that you need to be a tech wizard, let alone a video game wizard, to be able to translate the Constitution in light of new technologies. The question of whether NSA surveillance is or is not like a general warrant may be informed by basic details of how the program actually works. It's important for the government to disclose exactly what information is being collected, when it's being accessed, and under what conditions. And that's why I think it was important for the constitutional debate for the administration finally to release the OLC opinions that it had invoked to justify the NSA surveillance to begin with, and the previously secret Foreign Intelligence Surveillance Court decisions, just so that people knew the basic details of how things worked. And the White House Commission of the Privacy Oversight Review Board helpfully collected information explaining exactly what information was being collected. And very distinguished technologists like Ed Felton at Princeton help us understand how many people potentially have their telephone numbers accessed when the government is looking at what it calls several hops. In other words, not only at the suspect's calls, but every person that person calls and every person those people call. So as Felton has noted, and Judge Leon, I think, picked up on as well, if I am a suspect and call Domino's Pizza, then every person who calls Domino's Pizza might have their calls examined, and it can get into some pretty high numbers. That degree of technical knowledge of how things work is important, but you don't have to be a technologist, and goodness knows I'm not, to understand the gist of how stuff works. I vigorously resist the idea that only technologists can make constitutional conclusions. This is not a subject for scientists. It's a subject for citizens and ultimately for judges informed by civic debate to decide. Technologies change, but constitutional principles endure, and the basic question of how to translate the Constitution in light of new technologies is one that belongs to all of us.